Hi, my name is Nahied Usman. I'm a patent attorney at Nath, Goldberg & Meyer. Today, I'd like to talk about a recent Federal Circuit decision that examines whether certain composition of matter claims are directed to a patent-ineligible abstract idea. While defining an abstract idea for purposes of patentable subject matter eligibility has been one of the more challenging aspects of U.S. patent prosecution, such issues have generally been restricted to certain technology areas such as software, business methods, and diagnostic methods. In its 2022 decision, however, the U.S. International Trade Commission, or ITC, turned this assumption on its head, deciding that the composition of matter claims of U.S. patent number 10508-502 or the 502 patent are directed to an abstract idea, and thus are directed to patent-ineligible subject matter. On appeal, the U.S. Court of Appeals for the Federal Circuit, or CAFC, reversed this decision. In U.S. Synthetic Core versus International Trade Commission, the CAFC reversed the ITC's determination in a Section 337 proceeding that the composition of matter claims of the 502 patent are directed to an abstract idea and therefore are invalid under 35 U.S.C. Section 101. The 502 patent claims at issue are directed to a polycrystalline diamond complex, or PDC, and recite structural elements of the PDC. As claimed in the 502 patent, the PDC includes a polycrystalline diamond table bonded to a substrate. At least an unleached portion of the polycrystalline diamond table is recited in the claims in part as a plurality of diamond grains bonded together via diamond-to-diamond bonding to define interstitial regions. In addition to these structural elements of the PDC, the 502 patent claims recite physical parameters of the diamond table, including specified levels of coercivity, permeability, and magnetic saturation. Essentially, a relatively larger coercivity indicates a smaller mean free path, which means more diamond-to-diamond bonding in the diamond table. Additionally, a relatively larger magnetic saturation indicates relatively more metal solvent catalyst in the diamond table. Initially, the ITC determined that the relationship between the recited magnetic properties and the structure of the PDC is loose and generalized, and that the recited magnetic properties are just side effects of the manufacturing process. The CFC disagreed with the ITC and overturned their decision, specifically faulting the ITC for applying step 1 of the Alice-Mayo test too narrowly and characterizing the magnetic properties of the PDC as side effects of manufacturing. It was viewed as important by the CFC that the structural features of the 502 patent claims were explicitly tied to measured magnetic properties, demonstrating their criticality. Importantly, however, the CFC distinguished the present case from prior CAFC cases related to methods or systems held to be abstract ideas. Specifically, the CFC stated that the claimed PDC is not an abstract result of generic computer functionality, but instead is a physical composition of matter defined by its constituent elements, dimensional information, and inherent material properties. Accordingly, the holding in this case reinforces the general understanding that claims reciting new compositions of matter are not directed to an abstract idea and do constitute patent-eligible subject matter. If you'd like to learn more, you can read an article we recently posted on our website about this case. You can also submit any questions you may have to ip@nathlaw.com or call us at 703-548-6284.